Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday here at 10 a.m. on the Bottled Business Sense show. I'm Rick Moscoso, your host for today's episode. Welcome, everyone, back to the show, to our returning viewers and listeners out there. And if this is your first time, welcome. We are a simulcast show here on our YouTube channel as well as on the Blog Talk Radio. And, you know, Bill and I have been doing this for a while, and we love sharing our expertise with our audience base out there. Bill from legal aspect, how to protect your business and run it efficiently, as well as myself on the marketing and video marketing side. We love sharing our expertise for our viewers. And if you want a sample of what we've done in the past for you and for our viewers, go ahead and take a look at our library on bottledbusinesssenseshow.com. There's a whole host of things out there. You can also reach out to us on email at bottledbusinesssenseshow@gmail.com for any comments, suggestions for new episodes, as well as feedback that you may want to provide for us, and reach out to us on social media as well, on Facebook, Google+, and Twitter. So with that being said, we'll jump right into the show this morning, and I want to bring on my co-host, Bill Bernard, on the other side. He's looking all dapper this morning, and I want to welcome him to the show. How you doing today, Bill?
Doing great, Rick. Thanks. Glad to be here as always, and we got I think a real exciting show today. It's a little technical in some sense, but I'm going to try to make it as easy as possible for everybody, because for years now, in the recent years, I should say, asset protection trusts have been very valuable to protect businesses, to protect personal assets. And of course, the big question I always get is, do I go offshore or do I do one of the new domestic asset protection trusts? So I thought what I'd do is explain a little bit of the terminology, and then basically go into what the difference is between a domestic and an offshore trust, and then which trust would be better depending on what your goal is in setting up the trust. So I think I just want to start out by telling everybody that asset protection trusts are available in many states, but the several states I want to talk about are Nevada, Delaware, Alaska, and South Dakota. And let me just say that the purpose of these trusts should be obvious, and that is to keep assets out of the hands of creditors. You don't want creditors getting a hold of your assets. Now, there's a couple of caveats that you have to be aware of. But again, before we get into that, let me explain a little bit more of the terminology so we can set the stage. There's a beneficiary of the trust. Everybody should know what that is by now. The beneficiary is the individual who receives the assets that are in the trust. The person who sets up the trust is called the trustor or the settlor, S-E-T-T-L-O-R. You, as the settlor, have to decide whether you want to be a beneficiary of the trust or merely the settlor of the trust. So in other words, you can be the settlor and a beneficiary, or you can just simply be the settlor and have beneficiaries other than yourself who you're going to leave the assets to. The creditor in the examples we're going to be talking about is someone who has filed a lawsuit against you and has won, and now wants to gain access to these assets that are in the trust. So starting from there, let's talk about a non-self-settled trust and a self-settled trust. A non-self-settled trust is a trust where you're the settlor but not one of the beneficiaries. A self-settled trust is where you're the settlor and you're also one of the beneficiaries of the trust, meaning that you have access to the assets you're putting in the trust, but you still want to protect them from creditors. Remember that typically in years past, millions of dollars have been placed in these trusts, and the idea was when it was a non-self-settled trust, to protect your son or your daughter or your wife or whoever it might be from a creditor who has won a lawsuit against you. That means that whatever this beneficiary is going to get is protected, because even though the lawsuit has been won against you, those assets are going to the beneficiary, not you, and so they're protected from any creditor invasion. So the question became, what happens if you are a settlor and a beneficiary? What happens, in other words, if you've created a self-settled trust? Well, that is what we have been referring to as an asset protection trust. In 1997, Alaska attempted to stop the overflow of funds going into offshore trusts, because when you're in an offshore trust, no creditor can reach it. So how do we have an offshore trust of sorts in the United States? In other words, how do we have a domestic asset protection trust that is self-settled, where you're the settlor and the beneficiary, and where it's not an offshore trust? It's a domestic asset protection trust. The best examples would be Nevada and South Dakota. They have statutes that say that assets can be shielded in as little as 6 months. So here's what happens. You create an asset protection trust in Nevada or South Dakota. You then publish that in a newspaper for 6 months. After 6 months, once it's published, after 6 months, in a small local newspaper, the assets are protected from any invasion by creditors, even if you're one of the beneficiaries. In other words, it's a self-settled trust. You're the creator of the trust, the settlor, and you're a beneficiary of the trust. So now, out of the two, for sake of expediency in this show and in the allotment of time that we have, let's talk about Nevada and their self-settled trust. First of all, Nevada does not impose any personal or corporate income tax on this trust, on these assets. Second of all, the trust is only subject to federal income tax. You file a federal income tax return on whatever money the trust makes during the year, as you would on your personal return. And the settlor can change beneficiaries at any time he wants, and it's all statutory. It's not dependent upon any court decision. You can do all of this stuff as laid out in the Nevada statute. And Nevada doesn't charge any registration fees or annual reporting fees or any kind of fees over the years for this trust to remain valid. So if we talk about these assets protection trusts now, and we want to do it in Nevada, or if we want to do it in South Dakota or Alaska or California, there are several specifics that need to be in place in order for it to be an asset protection trust, a domestic asset protection trust that is self-settled. And what is self-settled, Rick? Little quiz here. What's self-settled?
Oh, you're the settlor and the beneficiary.
Fantastic. Okay, let's hope everybody out there is listening as well as you are, Rick.
I'm paying attention, Bill.
Yeah, you are. You're doing very well. So, in order for it to be a self-settled domestic asset protection trust, and by the way, Delaware is another great state for this, it has to be irrevocable, cannot be revoked, unlike your typical revocable trust, right, that families set up. Number two, it has to have an independent trustee. It cannot be a blood relative or an employee or one of your agents. It's got to be somebody independent, a third party. Number three, it cannot require distributions of income and principal. In other words, you can't say, this is how much I'm going to get each year. The trustee has to decide in his own or her own independent judgment how much money you get as a beneficiary and a settlor each year or each 2 years or each 3 or whatever the time limit is. That's going to have to be set the individual judgment of the trustee. And number 4, it has to have a spendthrift clause. A spendthrift clause means that it's got to specifically say that creditors can't reach these assets. Number 5, the trustee has to be someone who lives in the state where the trust is. So if you get a Nevada asset protection trust or one in Dakota or one in Delaware or Alaska, the trustee, the third party trustee, independent trustee, must reside in that state. Okay, that's number 5, right? Number 6, some or all of the trust assets must be in a bank account located in that state. So some of the assets you own are going to have to be in that state where you got the trust, in Dakota or in Delaware or Alaska, whatever. So you would have liquid assets somewhere in a bank account that would qualify to have some of the assets in that state, right? So that's number 6.
What would constitute some of the assets?
Well, that's undecided, and that'd be probably on a case-by-case basis. You're going to probably want to distribute at least a fair portion, maybe a third, something of significance, not just a measly $2. That's not going to, it's not going to probably cover it. And number 7, the trust documentation and the administration of the trust must be in that state. So it stands to reason if you have a trustee in that state, that's where the trust is going to be administered if there are any problems that arise. That's where the law is going to apply. You're going to apply Alaska law if it's Alaska, Delaware if it's Delaware, Nevada if it's Nevada, right? Now, what happens if there's a bankruptcy? We should touch on this just briefly. A domestic asset protection trust can survive bankruptcy because the state law where the trust is located will usually apply. But remember this, one thing is certain. If you have a domestic asset protection trust, rest assured that the creditor, if we're talking about a large amount of money and this creditor has won a lawsuit against you and wants to get a judgment against you, that creditor is probably going to challenge the legitimacy of that trust. And maybe, perhaps, if they want to expend the money, take you to court. So therefore, it's going to be up to the court to decide whether or not this trust has met all the qualifications of being a domestic asset protection trust. Okay? Remember, this is where it gets a little interesting, Rick. If you have it in a foreign jurisdiction like the Cook Islands, and the assets are inside a foreign bank account, the assets are going to be protected because the creditor is not going to have any jurisdiction to go and try to reach these assets in a foreign jurisdiction. So there we have the Cook Islands versus domestic asset protection trust. Why have the Cook Islands come under some suspicion? Now, we're going to talk about a case in a minute that's very, very interesting, and I think this is fun because even though we're comparing Cook Islands versus domestic asset protection trusts, the interesting aspect of this is that the government, the IRS, has come down on trying to put pressure on these foreign jurisdictions, saying that we're going to do less and less business with you. We're going to not be able to cooperate with you, with American businesses, if you don't come clean and tell us what accounts, who has what in what account, so we can try to tax these people. That's the subject of a whole nother show. It's very intricate, but those are some of the challenges you have when you place funds in a foreign jurisdiction like the Cook Islands. So now let's talk briefly about a case in California called Kilker, Kilker versus Stillman, Stillman. It was decided in November 2012. It's an unpublished decision, meaning it's not an official decision published in the California Reporters, but it does have some interesting aspect to it with regard to the pitfalls of a domestic asset protection trust. Because the court in Kilker said, we want to decide if, not necessarily if the trust was done correctly, but whether the person who put the assets in the trust violated the California Uniform Fraudulent Transfer Act, meaning that if you hide assets in a trust, even if it's properly set up, from a technical standpoint, that money might be able to be reached by creditors if you set it up specifically to avoid that judgment. So here's what happened. There was a leaky swimming pool that the family built, the Kilker family, on an advice by a soils engineer. The soils engineer transferred assets to a Nevada Domestic Asset Protection Trust. The homeowners allege that the engineer's transfer of the assets was fraudulent because the business the engineer owned was in a office building vacant and that he didn't pay any rent on. So the homeowners also alleged that this was a shell corporation. In other words, it was set up just to avoid a transfer or avoid creditors from reaching assets. So the court said that even though the engineer occupied the office building from time to time, there was no lease, there was no rent paid, so commercial formalities were ignored. So the deposition of the soils engineer was taken, and he says in his deposition, this was the death knell of the case, I set this trust up for asset protection. Now, normally you would think, okay, what's the big deal? Why isn't that being honest? You set up a domestic asset protection trust. It must be for protection of some sort, right? Well, when he said that he set it up for asset protection, the court decided that that was good enough to show that it was intended to be a fraudulent transfer in order to avoid creditors. Well, the engineer appealed, and he said, well, wait a minute. When I set this up, I didn't even know that this creditor existed. There wasn't any problem with this creditor at the time. So how could I have set it up to avoid this creditor? And here's what the court said. If a creditor can prove, any creditor, whether he's known or unknown to you at the time you set up the trust, if that creditor can prove that the transfer was made, here's the key buzzwords, to quote, hinder, delay, or defraud any creditor, then the Uniform Fraudulent Transfers Act can step in, nullify the trust, and those assets can be reached by the creditor who won the judgment against you in the lawsuit. So the key then becomes, when you set these up, can you avoid doing it so no one can show that you did it to hinder, delay, or defraud a creditor? Or do you want to opt out and go for the Cook Islands, where there may be a little more security, but where you may face IRS problems down the road? Typically, you might not, but that's not to say that it won't get more dangerous in the future, because the IRS is trying to really regulate these foreign jurisdictions by putting pressure on them as much as they can. So here's the answer then to the question that everybody must be asking. Do I get an asset protection trust? If you have a lot of assets, if you're wealthy, if you have a lot of assets and you want to protect them, or if you have a few assets that just happen to be very valuable and you want no creditor to reach them, I say from the beginning of this show on how you do asset protection. I'm going to assume that even my co-host doesn't recall, so I'm going to just mention it to him, and I'm going to mention it to everybody out there. You do asset protection above board, not trying to hide anything, and most importantly, you do it little by little by little by little. You do it in a schematic over time that shows this is your habit. This is what you have been doing for years. So it makes it more difficult for a creditor to come in and say, you did it solely to hinder, delay, or defraud me. Yeah, that's going to be much tougher to prove if you do it over time and start and don't wait and do it at the last minute, especially with a lawsuit pending. So this is what you do. You get an attorney, you do this over time, and you plan ahead. That's asset protection, planning ahead. I've written up articles on asset protection. I posted. People should go look them up on actually what is asset protection. I think I did a 3-part series. I posted them on various sites, including LinkedIn. You do it over time. You make sure that if your deposition is taken, you can say, no, I've been doing this since uppity up year, man. I've been doing this on a steady basis. I didn't do this to hinder or defraud any creditor. This is part of my asset protection plan that I've been doing for years. Look at my track record. I've been doing it little by little. I just didn't throw a ton of money in there in 6 months before this lawsuit. I've been doing this for the last 10 years, and I've been adding to it little by little by little. And then you're going to have to rely on a judge who knows the law and who can interpret the law and who will go ahead and do justice to the trust that you set up. Remember, too, that a lot of creditors will not bother to fight a domestic asset protection trust because it does cost some money to file a lawsuit and proceed. And depending on what you're owed, what you owe them, it may not be worth their while to make the effort to institute this lawsuit. Because remember, when a creditor gets a judgment against you, in order to prove a fraudulent transfer, that creditor now has to file a totally new lawsuit alleging violations of the Fraudulent Transfer Act. He can't just say, okay, it's a fraudulent transfer, judge, decide. He's got to file a lawsuit, go through discovery, prove it. So he's got to do another lawsuit and get another judgment to prove it was a fraudulent transfer just so he can reach the assets in the trust to get the money owed him from the first lawsuit that he already got a judgment in, right? So that's some of the intricacies of this process, and people have to decide, do I want to Cook Islands or some other foreign jurisdiction? There are others as well. Or do I want to try a new domestic asset protection trust in Nevada or Dakota or Delaware or Alaska or even California? So
for the average viewer out there that's listening to this that really doesn't understand the structure of this, in a nutshell, give us what are the advantages then of doing a DAPT like you're talking about here versus an irrevocable trust in a state that you didn't mention? What's the difference? What's the main difference?
Okay, so when you say DAPT, tell everybody what that means.
That domestic asset protection trust.
Good. See, my co-host is.
I learned something, when you talk about this stuff.
Listen, he's going to qualify as a paralegal before you know it. I'm telling you. Well, if you set up an irrevocable trust, typically you don't have any control over that trust. The trust now owns the assets. So in a typical grantor's trust, an irrevocable trust, you are what? It's a non-self-settled trust. And you have the assets in there to be protected from somebody else, but you typically want those assets to go to beneficiaries other than yourself. In a domestic asset protection trust, which is also irrevocable, it allows you to form a self-settled trust, meaning, again, you can be a beneficiary as well as the creator or the settlor of the trust. So those are the distinctions. And an irrevocable trust that's not self-settled, that's not a domestic asset protection trust, there are going to be very few challenges to that because it's not a self-settled trust. In other words, the creator is not also a beneficiary. And so the creditors really want to reach the assets of that beneficiary, of that settlor, who is also a beneficiary. In a regular irrevocable trust, they're not going to reach the assets of the beneficiaries who are not you, because the spendthrift clause prevents them from accessing funds that are due to beneficiaries and not due to the settlor himself, who's the one who has the judgment against him.
Right. And like you had mentioned, there's only a handful of states then that you can do this in, correct?
They're becoming more and more. I would say they're probably about anywhere between, I don't know the exact number, 10 to maybe 12 or 17, somewhere in there. But the most popular ones are Dakota, Nevada, Delaware, and Alaska. That's the four states that I would tell you to go to, specifically South Dakota. Those are the four that have the statutes that are the best. And out of those four, South Dakota and Nevada allow you 6 months. In other words, you just publish it in the newspaper for 6 months and you're protected. Doesn't mean a creditor can't challenge you later on, but because that's statutory, you could make the argument that, hey, I did this, I gave 6 months notice, I didn't do it to hinder or delay any creditor. Now, when you do it, make sure there's no lawsuits hovering over your head or a lawsuit that you're expecting to come down the pike. That's why I say do it. Do it over time. Do it in Nevada or Dakota if you want to take advantage of the 6-month notification statute, but do it over time as well. In other words, can do it, start it in Nevada or Dakota, and then continue to do it over time periodically. Now you got the best of both worlds. You got the 6-month notification statute working for you, and you have done it over time. So it's going to make it more difficult for a creditor to say, hey, he's done it specifically to hinder or delay or defraud me. Okay.
So if you had a significant trust, then let's say outside of these states that you're saying, and you decide to initiate a DAPT in one of these states, you can over time then gradually move things from that existing trust to your DAPT. Is that what you're saying?
Well, you can't move. You mean, are you talking about a revocable trust or an irrevocable trust? When you say about moving it to the DAPT?
Yeah. I guess I'm talking about a revocable trust.
Yeah, if you have a revocable trust, you can revoke it or change it anytime you want. So yeah, you can move assets in and out of that trust all you want without a problem. And if you want to move some of those assets that you have in an irrevocable trust into the DAPT, you can do that. And remember, this is good for businesses too. What if you might have a business that you own and you want to have this business be protected? Not just your personal assets, but you might want to protect the business interest. You might want to set up a DAPT to where you're leaving half of the business to your wife, and then your wife sets up a DAPT and leaves the other half of the business to you. So no matter who dies, that half of the business goes back to one of the owners of the business. Mm-hmm. So there's all kind of intricate ways you can do this, but you got to have an attorney on board who knows how to set this up. They're not cheap, but they're well worth it if you have the assets to be protected.
Yeah. So who's the ideal client that would want to take advantage of DAPT?
Anybody who's got assets that they believe are valuable. An interesting question. Somebody said to me once, "What's your house worth?" And I remember talking to this person about it and saying, well, the house is worth whatever somebody's willing to pay for it, meaning that things in life sometimes are relative. Values are relative. If you believe you have assets that are valuable to you that you don't want reached, but may not be assessed as valuable in the general market, well, then that might be something you want to consider. A DAPT may be something you want to consider. On the other hand, if you've got assets worth $1 million or a couple million and you want to protect it, or if you have assets worth $500,000 and you want to protect it, if you believe that these assets are valuable to you enough to where you want to take the initiative to protect them, then DAPT. There's really no ideal client when it comes to asset protection, in my view. It really depends on the person who believes that their assets are valuable to them, whatever they may be. I've seen people make initiatives and set up trusts that have $200,000, and I've seen people that have $2 million and above do it. So, and I've seen people with both of those amounts that do nothing. And they die and everything goes to probate, and guess what? Guess who makes the money there? Yeah. So I don't know that there is an ideal client, but certainly as you go up the scale and value of your assets, it may, for a practical purposes, be something anybody might want to consider, Rick.
Right. Well, great. Well, this was a great episode. And like I said, I've always said this in the past, Bill's knowledge of the law and these types of topics, he makes the complex sound understandable for the layperson to comprehend. So, folks, if you have any questions in regards to setting up a DAPT or even just a trust, Bill's got the knowledge, the know-how, and the willingness to take your call if needed. Bill, why don't you share that? And then also, why don't you touch upon your new trust site that we had set up a couple of months ago, and share that with our audience as well.
Okay. Yeah. The trust site is protectyourestate365.com. You can reach it by punching that in, or you can do the short version, PYE365.com. And this is a trust set up for basically the working people of our country who need access to, at an affordable rate for trusts. If you wanted to adapt or something much more expensive, you can certainly reach me through that site, and we can set one up. But the other site would be wfblegalconsulting.com. Bill at wfblegalconsulting.com would be my email, and my phone numbers, both 949 would be 413-6535 and also 698-6222. And you can reach me. Remember, what Rick said is true, that we can do anything that you want to have done, but these are basic principles that we talk about on the show because of the time allotment that we have. Don't think for a minute that you shouldn't sit down specifically with your lawyer and go through the specifics of your assets, so the trust that you feel is best for you and your business and your family can be put together according to the specifics of your specific case. So it's everything that works for one person may not work for another. So you need to really sit down with a professional. Do not do this online, folks.
Yeah, we've talked about that in the past. So, folks, if you have any questions, please reach out to Bill. He's an expert, obviously, in this field, and very knowledgeable, and he's a likable guy. So please reach out to him, give him a call. I'll be happy to help you out. So, folks, thanks for joining us again here on the Bottled Business Sense Show. I'm Rick Moscoso, your co-host. Today, on the other side is Bill Bernard, and on behalf of the Bottled Business Sense Show, have a profitable week, and we will see you again next Tuesday at 10 a.m. right here on the Bottled Business Sense Show.
Take care, everybody.